And I will tell you from personal experience, no, there isn't. We are the Erwin Rommel School of Law, and our Babylonian ghetto address is care of 4842 North Magnolia, Chicago, Illinois, 60640-4710. Our phone is 773-878-0681, dedicated fax 0682. We are going to lunch. You get 60 minutes, and it's battle stations in 60 minutes. Thank you very much.
All right, let's get, I've got a few loose ends here I need to tie up, and I will be out of your face before the end of this set. If any of you want to ask questions of me, you're going to have to come up here, and you're going to have to do it fairly soon, because I should be through with this fairly easily. Peggy, when I get through, are you up to another set? Okay. What I'm going to do is I'm going to go, I'm going to put Peggy on. When she gets through, Dwayne Rogers comes on, so when I'm through with these few last notes I've got for you, I'm through for the day, or actually for the weekend, and then, you know, my other officers will take over and finish you up. First thing I want to point out, you may have noticed that Peggy isn't bashful, and I've got to tell you, well, let me tell you how good she is, because she will never tell you this herself. She's so good in an open courtroom that when she walks into a courtroom, normally about 24 lawyers will file in behind her just to watch her in action. You can do the same. Another thing, some other minor things I want to cover. Whenever you sign a legal document, you sign it in blue ink, because if you sign it in black ink, you will not be able to sort out the Xerox copies. And any copy that is signed in blue ink becomes an original. Next thing I want to point out is Ambassador Fox reminded me during one of the breaks, is that Blackstone's commentaries were the law book that everybody had prior to our Revolutionary War. In other words, it's a real good summary of the English common law, and it's definitely something you should have right after the Rules of Civil Procedure and Black's Law Dictionary. One of the things I did not cover was discovery. I'm going to come back to that in a minute. There are other law book publishers besides West Publishing Company. West Publishing is kind of geared towards prosecutors and big business and big government. There are other companies like the Mitchie Company out of Virginia, M-I-C-H-I-E, Clark Boardman out of New York. There are a number of other law book publishers, and I got to tell you, some of these law books are literally worth their weight in gold. I bought one set of books by McCarthy, some outfit out of California. I believe that, I'm trying to think of the company, that might be Matthew Bender that carries it. It's called Bad Faith Insurance, What to Do When Your Insurance Carrier Stiffs You. And a friend of mine paid $180 for these books, and he read the books, and I coached him through a bad faith case, and he collected $10,000. And then the skinflint was going to send the books back because he didn't need them anymore, so he could get a refund. I said, no, I'm not going to allow you to do that. I said, I need these books. I use those books, and thanks to that one set of books, I've had 5 bad faith insurance companies or bad faith insurance cases that I've walked people through, and I have lost 0 of them. It's the one type of action when an insurance company stiffs you. The courts have no sympathy for insurance companies. They're really kind of neat outfits to sue because the odds are in your favor. Another thing I want to point out here before I get back to discovery is that, and I've said this repeatedly, is that the law is a weapon. Now imagine yourself in 1797, you're on the frontier, and you've got a problem with an Indian war. Well, you have one of 2 choices. You learn to use the weapons yourself, or you hire mercenaries, because nobody is going to come over free gratis and kill your Indians for you. Next thing is, this is also from Sun Tzu, is what is important in warfare is to attack the enemy's strategy. And we've already given you examples of that. If the enemy's strategy is to send motions that you don't know about or to bribe the clerk, don't attack what he's doing, you attack his strategy. And when you derail an attorney's strategy and they see it coming from a pro se litigant, a lot of times it's like they'll look at you like a truck ran over them because that's the last thing they were expecting. In some courts, some federal courts, what you will have to do, and this is also true of a lot of state courts, is when you have a motion pending, in other words, you want to put in a motion to do this or a motion to do that, you will have to call the clerk and get time, date, and place. In other words, you have to set it for a hearing, and then you have to notify the other side. You'll see that in some courts, and in some courts you just throw the stuff in and they get to it when they can. Now, what I want to cover on discovery, because a fellow brought this up during the break, is that a lot of times what will happen is when you make somebody snitch on himself, he will buck like you can't believe. Well, discovery goes this way. Number one, you file for the discovery. You're asking somebody, say, Federal Rule of Civil Procedure 33, written interrogatories. You ask a guy up to 25 questions. He refuses to answer. So then you go in for what's called a motion to compel. And what you're doing is you're asking the judge to issue an order to tell this guy he's got to answer the questions. Well, of course, he figures you don't know any better, so he doesn't answer the questions even after there is a court order. Court orders are not self-enforcing. The next thing you do is, and there are one or two things you can do here. You can apply for sanctions, that's Rule 37, or you can ask the judge to cite the other side for contempt of court. Now, what will happen is if you play this out, now here's the beauty of this discovery system. It's not supposed to be used like this, but hey, you know, any weapon properly applied, if somebody else doesn't like the way you've applied it, so what, as long as it doesn't get you in trouble with the system itself. What you can use discovery for, in other words, see, most people, they'll throw in like 25 questions. Not me. I'll throw in 5. I'll get those answers. I'll throw in 5 more, and I will keep continuing to build a trap for them. But actually, one of the other things I'm doing, and I'm not going to cover this too much because it's already in my books, but one of the other things I did not cover in my books is this, is that when you file for discovery and you get motions to compel and you get sanctions, there's only so much of this discovery, motion to compel, motion for sanctions crap the courts are going to put up with from the person who is not cooperating. And that goes for you too. In other words, if you're a defendant and you think you can get cute and drag your feet and run somebody through this, don't even think about it. And anyone who's got 2 brain cells to rub together will not think about it either, for the very simple reason that if you do this often enough, and sometimes it only takes like maybe 3 times, the judge will get so ticked, and he's got the statutory authority to do this, he'll issue what are called termination sanctions. You might as well not have even answered and got a default judgment, because what the judge is saying, you refused to cooperate in discovery, you didn't play by the rules, you just lost the chess match, and the appeals court will uphold it, and it'll stay that way for all eternity. So, again, you've got to play by the rules, and you've got to play by their rules. And when I say their rules, I am not talking about the rules they make up as they go along. I'm talking about the rules of civil procedure, the statute law. You've got to understand how the game is played. Now, again, what's going to happen next is Peggy Daddick. Why don't you start up here, front and center. I'm basically through for the day. I'm going to turn Peggy back over to you. Oh, wait a minute, I got one question. Hang on. Up here to the mic, please.
I have a trial coming up next month, and they've asked for a jury trial against me.
Okay, whoa. Criminal or civil? Is this a civil trial for money damages or a criminal trial they're going to try to lock you up?
They're trying to get money damages.
Civil, okay. State or federal?
State.
State, okay. What state?
North Carolina.
North Carolina, okay. All right, now that we've established that you have a state civil trial, which I assume you are the defendant, correct?
Yes.
Okay, plaintiff and defendant, you got to be one or the other, okay? You are not the suer, you are the suee. That's right. The defendant, all right? Okay, now what is the question? I've established the parameters of where we're operating. What is the question?
We had a contract, and I sold this guy a piece of property. I gave him 60 days to exercise an option on another piece of property, which he did not do. So then, 2 or 3 months later, I called him and sent him a note and saying, if you're going to do anything on this other piece of property, you need to do it. His comment was on the telephone, he said, well, I don't even have the money right now to pay the lawyer to do it. But what he did in the meantime, he gave me all of his down payment on the first piece of property so that he could take his second piece of property with no down payment.
Okay, what's the question?
So now, after his time run out for about 6 months of the option, then he sent me a letter and he says, I'm going to sue you.
Hey, wait a minute. Do you have an attorney on this case?
Yes.
You have an attorney?
Supposed to have an attorney.
Okay. My one question to you is, I already see what this is, okay? In other words, you had a contract, you had offer and acceptance, which is what you have to have in a contract. If you make an offer and the other side doesn't accept it, that is not a contract. He's got nothing to sue you over. My question to you is, has your attorney filed a motion for failure to state a claim? Yes or no?
No.
Then get on it. Get on it. Well, that's only federal, not necessarily. North Carolina's 12B6 too? Okay, man just told you, that's what it is.
Well, what now?
North Carolina Rule of Civil Procedure 12B6, and in fact, this is the fella that just told you that, was just primed me on the discovery thing, because it slipped my mind. But this guy here, go back and listen to him because he's a veteran. All right, he's been on the battlefield more than once. Yeah. Motion to dismiss for failure to state a claim, and if you would, let me take the next fella here.
Okay.
Okay?
Thank you.
Yeah.
I'd like to ask, what is the patriot mythology that's grown up in connection with the use of without prejudice relative to UCC 1-207?
Okay, UCC-1-207. It has all the legal validity of throwing chicken bones on the ground and predicting the future, okay? The problem you have with the Uniform Commercial Code is this. Number one, it is a uniform commercial code. It does not apply to criminal actions. It does not apply to most actions where the state comes against you. It only applies to transactions against merchants. But you have another problem, is that the UCC is only the law in the states that have adopted it. Some states have adopted it entirely, some states have adopted it in part, and some states have not adopted it at all. So what you have to do is, if you think you have a UCC problem, and I've run into this before, what you've got to do is, see, I'll guarantee you didn't read the statute book on that, right? And I'm not trying to front you off, but I'm just asking a question here. You have not actually gone to the statute books and read the UCC 1-207 and how the courts have interpreted it, correct?
No, I have read it.
Okay. No. I'm asking you, have you read the cases?
I don't believe I've read all the cases, no.
Oh, okay. What I'm telling you is UCC-1-207, basically what it does is, if you really want to know, you put that on a legal document, and I've got a fellow here, I'm not going to mention his name, he had a jam-up piece of work, and then he signed it, UCC 1-207. It brands you as an amateur, okay? In other words, it basically tells the court, this guy doesn't know what's going on, don't use it, okay? Unless you happen to have a transaction between merchants, then that's fine. But look, every statute has a particular use, all right? Uniform Commercial Code, in most places, it's got nothing to do with anything, okay? You take the next one.
Michael, UCC 1-207 says performance or acceptance under reservation of right. In your state code, in the index to the state statutes, there will be a listing for either commercial code or uniform commercial code. If you hear talk about the UCC and you want to apply it in the states, don't use UCC, use the state number, and be double damn sure that your state's number matches the UCC number that you are prattling on about. Thank you.
Okay.
Go ahead.
Yeah, I live in South Carolina. Company in Boston.
Whoa. Back up from the mic just a bit, will you? Okay, now.
I'm in South Carolina.
You're in South Carolina.
Company in Boston.
All right.
Took some money out of a mutual fund account at the request of the IRS without a court order, sent it to the IRS.
Okay.
How could I sue them from South Carolina to Boston for $3,000? And can I get punitive damages on that?
No, you can't, because here's your problem. The IRS is the one area in which you have even fewer rights than anywhere else.
They did not have a court order, though. Doesn't that make a difference?
You have a court order that says what?
No, they did not have a court order. Now, I've got cases where they can't take you money without a court order.
Okay. Now, if you have cases, do you have any of those cases with you?
No, not with me.
Okay. Now, are these federal cases? How recent are they? Have you shepherdized them?
1980s.
1980s. That's fairly recent.
Yeah,
Okay?
shepherdized them. They're still
Now,
on the
the
books.
problem is, wait a minute. One of the problems we're going to have here, because everything I've seen in the IRS, the way that they normally operate, they even have what they call the anti-injunction statute. In other words, if the IRS takes your money, you can't even begin to get it back until you have litigated it. If they're getting ready to put a levy on you, if they're getting ready to take everything you own, you can't litigate it to try to stop them. In other words, they actually have federal statutes that say when the IRS has got its beady little eyes on your bank account, there are actually federal statutes that say that what's going to wind up happening here is that no court is going to issue any type of injunction to keep them from doing what they're prone to do. And they've got a really slick setup in that if you want to adjudicate the thing in the tax court before they get the money.
No, I want to sue the company, the mutual fund company that gave them my money without a court order.
The problem is, though, is that here's what's going to wind up happening. They had a levy from the IRS, right?
But there were no warrants of restraining. I've got a case that says we've got to have warrants of restraining.
Okay, if you have a case, all right,
I've got a case.
and quite frankly, I'm a little skeptical, all right?
No, I've got the case.
I understand, but who was the case issued by? Which court did it come out of? Are we talking, is this a federal district court case? Is this a, Boston would be the First Circuit? Okay, is it a First Circuit case? What kind of a case is it? Okay, well, so you've got to find out, because let me give you something real quick here. If you have a federal supplement case that says that, it won't hold water for one very simple reason. Federal district court cases are not precedent. They're not even precedent in their own courtrooms.
This case came out of U.S. Reporter.
Okay, if it came out of the U.S. Reporter, United States Reports, you mean?
Yeah.
Okay, that would probably be a Supreme Court case, all right?
Yeah,
But let me caution you on something. Okay, let me caution you on something. And I'm not saying this to denigrate your intelligence or anything, because I run into this all the time. I've run into it for 25 years. People have a tendency, and I'll guarantee you if this is what it is, and I don't know that it is. Okay, I haven't read this case. You don't have it here. I can't read the header notes, so I'm basically flying blind. I don't know if you're right or wrong. But the one thing I want to caution you about, when you start reading a case, and this is real easy to do, you may have 4 separate things on one page, all right? And one of them may say exactly what you're saying. But if you read down a paragraph or 3, you may find that what they're actually addressing is a mistake of law somebody made, and then down here they're telling you why it's wrong. I don't know, but it's been my experience with IRS cases that everything is in their favor. And the thing is...
Just Kurt, I may have the case with me. Are you going to be around?
Yeah, if you have the case with you, you bring it out here, and I'll take a look at it. What I'm going to do is, because I'm through for the day right now, as soon as Peggy gets back up here, is if you have that case, what I want you to do... Well, wait a minute. What I want you to do is if you come outside with me and you show me this case, and you and I are going to have a discussion, if I show you something you haven't seen before, I want you to come back up here and explain it to the audience, okay?
Okay.
Fair enough?
Fair enough.
Okay, Peggy, let's get back on deck. And that's it for me for the day. And incidentally, I appreciate all you people showing up. You still have quite a ways to go.
Okay, more war stories, I guess. Michael mentioned Black's Law Dictionary to you along with the rules of court. Let me tell you what we found has been the best way to use Black's. When you go to the law library and you pick up some cases, you find some cases that you think are going to support your position, or when you get any piece of paper from the other side, the smartest thing you can do is to sit Black's Law Dictionary on your desk and read that paper with Black's right alongside of the piece of paper. And any word in that document that you even think might have one English meaning and one legal meaning, you look up in the dictionary. And after 3 or 4 weeks of doing this, you cannot imagine how much of that legal terminology is going to start sticking. Because what happens is when you go to read those cases in the beginning, you go to the law library, you find your first case, you do some research, it is dry material to read. Okay? It's not fun. I mean, you sit there, you read the first paragraph, and you get to the end and you say, what did I read? Because it's really not easy to understand. I'm going to tell you folks, you need to read it 3 times, 4 times, 5 times. That's what you have to do. But by the 5th time, it starts to clear up, and you start to understand it, and you're getting something out of it. And that's the way you read law material. And 3 or 4 months down the line, you'll only have to read those cases once when you find them, because the terminology will be there. It's a new language. It's just like learning a computer. It's just like learning a new job. Every job has buzzwords. The legal system isn't any different. The only difference is they've convinced all of us that we couldn't possibly understand it. But they have the key. The key is Black's. You've got to have that book. That's one book that absolutely belongs in your library, along with the Rules of Civil Procedure. Another thing my husband said to me, if you have a question, would ask that you come up to the microphone. My husband said to me, make sure you tell everybody, and this seems so basic, but it's very important, that if they've got something that's going on in court, that they absolutely have to get there on time. I got to tell you, I saw somebody do this just last week. They had a dynamite motion put together. They were going in to recuse a judge who was very unfair, very prejudiced against pro se litigants. They had the paperwork all lined up. They had a court stenographer there. Well, the court stenographer was there with her little tape recorder all ready. And 20 minutes later, after the proceeding had started, this person walked into the room. How could you possibly think that you could win if you're going to walk in late? I mean, even the judges are never late. They're always there on time. You just don't do that. You have to be there well in advance so that by the time you get into that courtroom, you're set and you don't have any problems. Yes, sir, you had a question?
Is there any specific important difference between the 6th edition of Black's Law and the ones that precede that, 5th, 4th, 3rd, 2nd, as far as you're concerned? Yes.
I know that there's a lot of information out about Black's in the different editions. I have never done a lot of research. I won't have a good answer for you on that. The one that all the lawyers use and the courts use now are, of course, the 6th edition. You wouldn't go back and look for old definitions to support your position today. That I can tell you. I
have a used bookstore, and I've had a run on Black's Law Dictionary, anything before the 6th edition. And I suppose it's the Patriots.
It is the Patriots. And
that's the reason for my question.
I'm sure there's valuable information in the old editions that may not have seemed appropriate for them to include in today's edition. But again, if you're looking for something to fight today in court with, you're looking for the most recent cases. Michael talked about shepherdizing. Shepherdizing is something that when you're first learning and they're saying to you, oh, did you shepherdize your case? You say, what in the world is that? Okay, well, it's not too much harder than learning the Dewey Decimal System in a regular library. I mean, you go in there and you learn how to do it. There's a very good book that's sold by Nolo Press out in California, and it's How to Use the Law Library. It's probably about $15 or $16, and it shows you everything that's in the law library. I think there's 3 or 4 pages on how to shepherdize. Michael has information in the cookbook, but if that's not sufficient, if you feel like you need more, then this Nolo Press book is a real good backup. Nolo Press is out in California. I don't know the number offhand, but it's listed on the 800 exchange because it is an 800 number. On the board. Okay, it's on the board. So you just, if you need the number for Nolo, come up here. Nolo has some good books out, Nolo Press. There's another good book that's put out by Nolo Press for those that are actively in court, and it's called How to Represent Yourself in Court. It's written.
Just repeat that number for the tape.
Okay, Nolo Press. Okay, 1-800-992-6656. And your bookstores, your local bookstores can get these in for you too, because we've ordered them down in Florida through some of the local bookstores if you don't want to order directly through Nolo. But the other book is How to Represent Yourself in Court. It's written by 2 attorneys, and This book is dynamite because it shows you how to organize your papers, okay? How to organize your files. You have to be very organized. If you go into a law firm and you see how they have your files set up, you pretty much have to do that so that you get something in the mail, you don't go to some box and start sifting through papers when you have a hearing tomorrow that's going to take you a week to find everything. You just file things as they come in chronological order. You get yourself a folder, you get yourself a 2-hole punch because the courts punch everything on the top of the sheet. 2 holes up here, that's how everything gets filed, and you might as well do the same for you. This way you go file 1 copy with the court, get your copy stamped, you bring it home, you make a log in the front of it, so you can just go to that log and say, in March I filed this, in March I got this from the other side, and everything is there because you're going to need it. When you get to the, I mean, things just keep coming back. They don't stop in that case. And later on down the line, when that lawyer says, we never discussed this, and you've got a record that you can put your finger on and say, wait a minute, this was decided and the court ruled in my favor 6 months ago, you're going to be real glad that's all organized.
Peggy, just following up on that last question, I did find a difference in Bouvier's the 1856 edition and the 1914 edition of the term voir dire or voir dire, which today is the process by which they ask intrusive questions of prospective jurors. And originally that meant the statement of a witness in a case that he has no interest in the issue at hand.
Oh, okay, that's very interesting.
It sort of swapped it around, translates as to speak the truth. But let me ask you about the court reporters. You talk about bringing the court reporter in with you, your own court reporter. I have heard that the courts will frequently not allow an unofficial reporter into the court. They would allow only the court's reporter, and that would be the official record, and there would be no challenge of it once certified. Can you?
Yeah, I'll be glad to address that. Okay, that's what they're going to tell you. If you call up, a lot of the courts will say, you call up the clerk's office and you say, well, I would like to know what I have to do to be able to bring my own court reporter. And the clerk will say to you, oh, you're not allowed to. We have our own official court reporters. Here's the answer. Weeks before the hearing, you have to put in a motion asking the judge permission to bring a court reporter with you of your own. Very simple. Here comes so-and-so, I would like to request permission from the court to bring my own court reporter in addition to the court's reporter to a hearing on such and such a date, such and such a time. The court will most frequently grant it when you come in advance. You cannot come in there at the last minute with your court reporter. They will not let her in the door in the federal courts. State courts, you've got to find out what your local rules are. But you definitely can. And I can tell you, we just ran into this. Michael and I had an appeal on a very old case that some lawyers had blown for us up in New Jersey. It was a car accident case where my husband had been injured. And once we found out how to do this in Florida, we went back and sued the attorneys and the insurance company in New Jersey who did that to us over there. So we lost the case at the first level, and we went up on appeal, and we had oral argument up in Pennsylvania in Philadelphia about 6 weeks ago. And on the way up, we said we had hired a court stenographer, and we had drive up from Florida, and on the way up we're waiting for this permission, and of course it didn't come before we left to go, but we did get permission. But it was gotten at the last minute. On the last day, we had faxed the motion in. They allowed us to do that. And everyone was in a meeting. The clerk's office was in a meeting. So I guess about the 5th phone booth stop on the way up from Florida, I finally got to somebody and said, listen, I'm stopping every 25 miles on I-95 on my way there to find out if I got the motion approved or denied. So the girl said to me, well, everybody's in a meeting, but let me see what I can find out. And she came back and said, oh, the judges said no problem, and you can do it, and the order's been approved. Well, I guess the clerk that the attorneys that we were fighting was in the meeting. The clerk that the attorneys that we were fighting was dealing with, he wasn't there. So when we arrived in the courthouse the following Monday, we got there, and the court reporter was there. And the clerk came over, this little guy in a real neat suit, you know, and he came running over in a panic. He said, "What are you? Who are you?" Because she had the the recorder and her microphone she was setting up at the panel. Because when you go up on appeal, if you have an oral argument, it's usually a 3-judge panel that's sitting up there that you have to address your argument to. And so she was setting up her microphones. And this clerk came running out, and he said, "What are you doing here?" And she said, "Well, I'm just setting up the microphones because I'm the court reporter." He said, "Oh, no, that's not allowed here." So I got up and went over to him. The judge wasn't in the courtroom yet. And I said, "No, we have..."
and Anderson in another court. That's the District of Columbia. So let's put away the appellant's reply brief. And let's go on to NATOA and DCTV. The liar for hire on this is a fellow named Peter Hopkins, and another liar for hire named Norwood. The law firm is Spiegel and McDiarmid in Washington, D.C. on New York Avenue. And I get this little background on this. This case against DCTV, the district court in Washington refused to file. They kept sending it back, and they said, oh, this is wrong, this is wrong, this is wrong. And so finally, I sent them an explosive letter and told them that you're finding every kind of phony excuse not to file this case. You've got to understand that that's actionable. Under the Constitution of the United States and the laws of Congress, you have to file this case. And when I told them that, they finally got it together, gave it a number, a docket number, and assigned a judge to it. And the name of that judge is Friedman. So Friedman writes Glendora a letter, and he says that, an order, so-called, and he says that Glendora has to respond to the motions to dismiss by Watson for the District of Columbia Public Access and by NATOA and Anderson. And so Glendora annotated all of that and said that Glendora knows how to respond to a motion, but NATOA and Anderson made no law of what they claim about having a local signer, and there is no statutory authority. You cite a law, Glendora tells them, and this is mere dictum. Well, I refuted that page of theirs, and I refuted this, and because they lied and because they misrepresented, I moved for sanctions on them pursuant to Rule 11, Federal Rules of Civil Procedure. And he practiced and practiced and practiced and practiced. All the different ways you could say I did. I did. I did. I did. Came time to shoot the scene. The detective said, did you see the woman drink the cup of coffee? And the little extra said, did I? This is Glendora, Chat with Glendora. I was up 4 hours last night, as I told you. So I think it's time to go Betty bye. Folks, I know a man who's divorced. He has 2 children. And they're teenagers. And he wonders, he has pangs of guilt. That he's causing his 2 children mental problems. Well, take one of them in particular. Is being divorced causing his son mental problems? You know something? It might be. Because you know what the situation is? The father doesn't love the little boy's mother anymore. I guess that hurts. I guess that could make you cry. I have to get on with this abyss of evil that I have uncovered in the United States District Court in Atlanta, Georgia. And I have to deal with one of the most reprobate, quote-unquote, lawyers I've ever encountered. His name is Richard Lombardo. He is as bad as Charles Sanger. There is no such thing, in my experience, as an honest and honorable Assistant Attorney General of the state of New York. They are all entrapped in the arms of the devil. They are all out to squander the great rights that we have, the great constitutions that we have, both federal and state. You can laugh when people say constitutions, but there are two of them. The United States and the state of New York, and maybe your state in Oregon, and your state in New Mexico, and your state in Connecticut, and your state in New Jersey, where a chat with Glendora goes every week. They are all out to ruin your inheritance. I am telling them that we know what they have sunk to. I'll go another step, and I will tell them that we are going to pray that they come back to being a Homo sapiens, an intelligent human being. We're very special. There's nobody around like us. Who's the next down? The apes, the gorillas. But they don't have the things that we have. They don't have compassion. Do they? They don't have a sense of humor, do they? They don't laugh. They don't have the technical advances that we have, although our advances technologically are very puny compared to what God knows, above and beyond what we know, and what God has created above and beyond what we can understand. So we go back to these people and we pray for them that they will come up to their level, the great level that they are created to be. And they will realize that there's not God and there's not a person over here. There's just one thing here. There's no more dichotomy. It's one. So the present and the instant notification to you people in Atlanta, Georgia, is a memorandum to the United States District Judge there, Clarence Cooper, that the New York State Attorney General cannot write legal papers. Letters are nullities, and the New York State defendants are in default. That's all there is to it. And Glendora wins. This is a picture of how I write these legal papers. They're all handwritten. Okay. This is the 7th day of the most beautiful, warm, caressing, friendly weather. In December, a week before Christmas. Hello, Penny. Under penalty of perjury, Glendora declares she is telling the truth, the whole truth, and nothing but the truth, and always has, so help her God. Further, she declares that she is fully familiar with the facts and circumstances, having personal knowledge of and participation in all events. Lombardo, Richard Lombardo, and the New York State defendants are not and do not. Lombardo does not know that he should write a grown-up legal paper, as did Mediacom defendants. Lombardo's letter is a nullity and has to be stricken. Lombardo does not address the United States District Judge. Glendora never granted her consent under Title 28 U.S. Code Section 36 636, to have her action handled by a magistrate. A magistrate is nothing but a teacher's helper. A magistrate is not a United States district judge. And you are entitled to a United States district judge, no matter how they want to cut corners. The Constitution of the United States, by Article 3, entitles you irrevocably to a United States district judge. No magistrates. And here's Sic Lombardo's excuse for existence, for bringing home a crummy paycheck and selling his soul for it. He writes it to the United States Magistrate Judge E. Clayton Schofield III, and that E stands for evil. And he should be writing to Clarence Cooper, the United States District Judge. He says, "Dear Judge Schofield," well, Judge Schofield's not a judge, he's a magistrate. And he leaves out the initials, CC for Clarence Cooper. In federal lawsuits, folks, you get the year, and you get whether it's civil or criminal, and you get the number of the case for that year. And in parentheses, you have the initials of the United States District Judge. That's a rule. And then you have, in parentheses, the initials of the teacher's helper, the magistrate. Says Lombardo, this office represents Honorable John F. de Blasi. Well, the first thing you do is cross out Honorable, because John F. de Blasi is not a justice of the Supreme Court of the state of New York for the 9th Judicial District. That's an unfortunate happening, but we've got to get in there and get him out. Glendora says he has been publicly censored by the New York State Commission on Judicial Conduct, and Glendora is working on his dismissal, picketing the courthouse with her sign that says, "Dump de Blasi." Barry Schwersky, Judge de Blasi's principal law secretary, and Glendora says Schwersky has been declared an agent of Cablevision by the United States District Court in Delaware. You remember that fight? That's a big victory. Radio stations used to say they're standing by, we're having technical difficulty. The tape ran out. I get tired of listening to all these evil reports, or these reports of evil. I get tired of listening to the fact that Karen Murphy, who should know everything about handling a lawsuit, is scurrilous enough, too, when she gets the paper, just to send it back, like a kangaroo, bounce it back. And kangaroo court. Boomerang, right? A couple of Australians. What should she do? She should take the lawsuit. She should look at the charges against her, the allegations against her, and she should stand up honorably and say, yes, you're right, or no, you're not right, or no, I don't have enough information to form a belief, which is a cheap cop-out. But that's what she should do. And then motions come in. She should oppose them. That's what how you handle a lawsuit, Karen Murphy, in case you've never seen one before. Now, Karen Murphy has been sued in about 6 courts, and this is the first time that the New York Attorney General has popped up an appearance, quote, unquote, so-called. Letters do not count. She still hasn't appeared because letters don't count. You have to write a legal paper. You have to write a memorandum, or you have to write a motion. That's how you move the court. That's how you address the court, with a motion. And the courts move all the time. They move from Post Road over to Quaropus, in White Plains, and they're moving all the time. The Cleveland court moved, and they don't forward their mail, and the Atlanta court moved, and I think the St. Louis Court of Appeals, I think the circuit moved. The whole circuit court moved. And certainly in Manhattan, the court moved from Center Street over to Pearl Street, across the street. Cost you $500 million. So they can go on and obliterate justice and forget that the business of the courts is justice. Okay, that's what moving the court is, move them across the street. And this letter comes from the old federal court, which is now the state. New York State has leased it, this building. Well, it used to be the federal court, 101 Post Road, East Post Road in White Plains. So, Stern, who is the, and Lee Clear and Albert Lawrence, and the New York State Commission on Judicial Conduct. And Glendora says to that, IBID, what she said in paragraph 9, on these defendants, Stern through commission have been sued several times the past 3 years by the Sassours. Their job is to protect us from bad judges. That's the job of the New York State Commission on Judicial Conduct. And they failed. Well, they at least publicly censured de Blasio. They should have got rid of him. But at least they did something. And so, says Lombardo, thereafter collectively the New York State defendants, who are named defendants in the above referenced action brought by Glendora in the United States District Court for the Northern District of Georgia. And Glendora says, well, we know this. As diligent students of Glendora's well-pleaded complaint, having read in its entirety, we know this. We all know this. In connection with the matter, a copy of what plaintiff to be a complaint or purports to be a complaint or purports to be a complaint and received by the New York State defendants. He doesn't dare call it a complaint. We didn't do anything wrong. You know, we'll lie. Okay, we'll sell our soul. We didn't do anything wrong. You know, we only took away people's rights. We only stole justice. We only kicked Madam Justice in the shins. That's all we did. We didn't do anything wrong. There's nothing wrong with that. You know, we work for the devil. This is good stuff. Well, this is exactly what the law mandates. Federal Rules of Civil Procedure, Rule 4D. But Lombardo is as unproficient in federal law as he is in New York State law. What he's saying is that they were only served by regular mail. That's what United States Code Rule 4D says. Excuse me, it's not United States Code. Well, it has a code number. It's Federal Rules of Civil Procedure. And it is codified. It does have a number. But that's what it says. You serve them by regular mail. See, he's trying to say because they weren't served personally and because they weren't served by certified mail and all this and that it doesn't exist. Well, sorry, Lombardo. As ever, you missed. Glendora says, read her last 4 pages, Rule 4D, affixed to the rear of Glendora's well-pleaded complaint. You see that these people had a civic duty to acknowledge the lawsuit, instead of lie and run the way you do, Karen Murphy. They had a civic duty to acknowledge that they've been sued and to save the cost of serving a summons. But you don't know that, Lombardo. You don't know federal law and you don't know state law. And Glendora says, this is hearsay. Where is your proof? Says Lombardo, it is my understanding that the court
has denied Glendora's application to proceed in forma pauperis and directed her to pay the filing fee, which Glendora has failed to do within the time allowed by the court. You see how they skim over the top and take off the frosting and never get down to the depth of it? Glendora says, Lombardo, as ever, deceives. He does not mention that Glendora protested the same, and I read that to you, and our argument that she does not have $150, and that Schofield is pro-rich and against the poor. Only rich people can go to court, folks. If you're poor, you can't go to court. Only rich people can go to court and seek their rights and to seek their justice. But you poor people, you can't go to court. You're not allowed in court. The door is slammed shut to you. Says Lombardo, I have also learned that the court has received from Glendora what purports to be a motion for a default judgment in connection with this matter. What purports to be. Another lie, another misrepresentation, and another ground for sanctioning you, Lombardo. Glendora says, A, stop deceiving, Lombardo. How did you learn? Come out and say how you learned. B, if you did learn, it's the first time you've learned anything. B, and so did all of the other defendants. C, quote unquote, what purports is another sleaze by Lombardo. This is Richard Lombardo, one of the many sleazes that you are paying a good salary to deceive and to lie and to cheat and to steal your rights. Now Glendora adds in big letters that Lombardo and the New York defendants to her list to be sanctioned pursuant to Federal Rules of Civil Procedure, Rule 11. Says Lombardo, I am here writing simply to bring, and Glendora says, stop. You said it very simply. Too much so. Says Lombardo, to bring to the court's attention the fact that the New York State defendants have not been served with a copy of the complaint. Sin has many tools. A lie fits the handle of them all. Thank you, my mother, for teaching me that. You know very well they received the complaint. The other defendants received the complaint. Mediacom answered, didn't they? They received it, and all he does is just lie. That's his only way out, is to lie. Go home tonight, Lombardo, and look at your children and say, I bought your shoes with money I stole from the public. I bought you food at the grocery store this week with money that I stole from the public. I bought you clothing, children, by cheating. All week long my job is to cheat and to lie and to steal from the public. That's how I bought you kids, your clothes. So you can be proud of me, kids. Go home and tell your children that, Lombardo. This is Richard Lombardo, an accursed assistant Attorney General in the state of New York. You have this too in Oregon, folks, and you have it too in New Mexico, and you have it too in New Jersey, and you have it, boy, do you ever have it in Connecticut. What Ethan Book Jr. has told me about your violations of your rights in Connecticut is abominable. So, says Lombardo, they didn't receive the complaint as required by the Federal Rules of Civil Procedure, a fact which I understand is reflected in the court's docket. Oh, yeah? Prove it to me. Quo warranto. Produce it. Produce it, Lombardo. Oh, yes, they have, says Glendora. And Glendora asked for double sanctions on Lombardo and de Blasi through the New York State Commission on Judicial Conduct. Lombardo is caught again by Glendora, a liar for hire. Says Lombardo, accordingly, it is respectfully submitted that Glendora's motion for default judgment should be denied. You do this in a letter? You don't know enough, Lombardo, how to write a notice of motion and an affirmation in support? You don't know that's what you're supposed to do? You write a puny, sick, pathetic letter. Glendora says it is not respectively, quote unquote, respectfully, quote unquote, when you lie, when you cheat, and try to win. Triple the Rule 11 sanctions, add to it 18 U.S. Code Section 101, 1001. I want you to be sure you look that up, folks. It's a little short paragraph, but it covers all of these cheaters. If they cheat, if they lie, if they misrepresent, okay? They're liable to you, okay? And they're going to be fined and they're going to be jailed. It's against the law to misrepresent, to cheat and lie. And that's the criminal code, which is Title 18, United States Code, Section 1001. Be sure you have that in your back pocket at all times. Glendora says they scamper like common fugitives. Here they are, the New York Commission on Judicial Conduct, and look what they're doing. Here they are, de Blasi, a Justice of the Supreme Court, Westchester County, State of New York. Look what he's doing. Karen Murphy, you the same, only in Nassau. Okay. Schwersky, you the perpetrator of scandalous and scurrilous lies. And you, Keitler, and Lawrence, and Stern, Gerald Stern. And look what you've sunk to. And he should have known enough to do this initially. But he always has to cheat. This is Lombardo. He hardly has an office over at 101 East Post Road. You should see it. I'm telling the court in Atlanta. Federal courts have such lavish offices. They're bigger than your apartment. I saw the office of a U.S. District Judge down at 500 Pearl Street. And I'm telling you, folks, you could have your Christmas Eve party in there easily. You could have your New Year's Eve party in there easily. Only I do not favor New Year's Eve's party. On New Year's Eve, you sit down and quiet and in sobriety, and you should say what you're going to do for the year and listen to what you're supposed to do. Okay, back to that. I'm telling you, lavish, thick carpeting, mahogany all over the place, marble all over the place, and you paid for that. They stole the money from you. And what do they give you in return? Do they give you justice? Oh, no. Oh, no. They just take more in for themselves. It's tainted money. It tain't theirs. Lombardo stood beside Glendora in a Westchester Supreme Court one day in a courtroom, lying so hard that he couldn't stop himself. And when the judge said adjourn, Lombardo scampered out of the courtroom as fast as he can, and I was on his heels. And guess what he did? He ran into the men's room. And I tell Cooper here that Glendora couldn't go into the men's room because Glendora is a she, not a he, because Schofield called me a he. Mentioned my paper as his, and in one place he said his or hers, which means he isn't paying attention, which means he's spitting these things out from the computer. And I couldn't go in that men's room and get a hold of Lombardo and look him deep into the eye and down into his empty or down in the place like the World Trade Center where his soul used to be. I couldn't do that. And Glendora, being she, could not follow him. Says Lombardo, Honorable E. Clayton Schofield III, and Glendora crosses out the honorable because I know evil Clayton Schofield not to be honorable. And then Lombardo says, listen to this, thank you for your courtesy and consideration in this matter. Ho, ho, ho. All right, Glendora wants to know what courtesy did Schofield do, Lombardo, that Glendora doesn't know about. I think this is ex parte, okay? Ex parte. And add this to the Rule 11 sanctions, and this to who to sue. Apologists to you grammarians, but I love it. It rhymes. Who to sue. It should be whom to sue. And he says, very truly yours. Another lie. Richard Lombardo, Assistant Attorney General. Look at this. Look at his signature. What's that tell you about him? Just look at his signature. What's that tell you about his mental state? Sprawled out, indecipherable, matches his thinking. And then he sends it to all these Barry Schwersky and Glendora and Garfine, James Garfine. He was a cute kid, but of course by now he's completely demoralized. He's been in the Westchester Supreme Court so long. Karen Murphy, Gerald Stern, Tony Logue. Who are you, Tony Logue? Another one? And Susan Reinhardt. Who are you? And Charles Sanders. I know Charles Sanders. I know Lombardo to be a clone of Charles Sanders. So you know what Lombardo's right. Sanders is, I have personal knowledge that Sanders is the same. So Glendora wants to know what are their addresses, and add this, the 10th cheat, to the Rule 11 sanctions. And who are these people? Conclusion, says Glendora, Lombardo's puerile letter must be stricken from the record. He said defendants de Blasi, through New York State Commission on Judicial Conduct, must be sanctioned. Or no, they should be sanctioned. He and these defendants, de Blasi, through New York State Commission on Judicial Conduct, must be sanctioned for $10,000 for the multiple violations noted herein of Rule 11, Federal Rules of Civil Procedure, dated December 23, 2002, Anno Domini, in the year of our Lord. Yours in truth, Glendora. This is Chat with Glendora, Box 69, Hopewell, New York, 12533. Opus 927. It took 7¼ hours of God time to write this, and it cost $7.03 to print and post it. And here is the service list, which is also the prayer list. Please pray for these people. Richard Lombardo, Karen Murphy, John P. de Blasi, Barry Schwersky, Gerald Stern, Lee Highclear, Albert Lawrence, the New York State Commission on Judicial Conduct, please pray. The Center for Judicial Accountability Incorporated, please pray. And to you, Glendora TV audience, the all-important public, and to Clarence Cooper, the United States District Judge in Atlanta, and put it into the who to sue pile. That will be Omnis 14. 11 sets. Under penalty of perjury, Glendora declares she served each of the above a true copy of her memorandum within of 10 pages, first-class mail on December 23, 2002, dated December 23, 2002, yours in truth, Glendora. A note here for me to remind you that I have been fighting the law-breaking of Charles Dolan for 9 years. It started on Veterans Day, November the 11th, in the year 2000. No, in the year 1993. In another century. Started a century ago. Jokes? Why do geese fly south in the summertime, in the wintertime? Why do geese fly south in the wintertime? Well, folks, it's just too far to walk. The Hollywood extra, he got a speaking part and in a movie, and the scene was that the detective would say to the little extra, "Did you see the woman drink this cup of coffee?" And the Hollywood extra was supposed to say, "I did." And he went home, the little Hollywood extra, and he practiced all the different ways you could say, "I did, I did, I did, I did." Came time to shoot the scene. The detective said, "Did you see the woman drink this cup of coffee?" And the Hollywood extra said, "Did I?" Did you know about the Beethoven fan, classical music fan, enthusiast? He went to visit the grave of his cherished Beethoven, and as he's standing there, he hears the Ninth Symphony being played. It's coming out of the ground, and it's being played backwards. And he hears the Eighth Symphony being played backwards, and the Seventh, and the Sixth, and the Fifth, all the way down to the First. He says to the gravedigger, "I don't get it. I'm trying to hear these Beethoven symphonies. They're all being played in the reverse order in which they were written. They're all being played backwards." And the gravedigger says, "Don't you understand? He's decomposing." Do you know about the three ropes, R-O-P-E-S, who were walking down the street, and they went into a restaurant, and they sat down, and they started to order, and the head waiter says, "Hey, aren't you ropes? We don't serve ropes in here. You've got to leave." And out on the sidewalk, one rope was very angry. And so he tied himself into a knot. He tousled both of his ends, goes back into the restaurant, and he's ordering, and the head waiter says, "Hey, aren't you a rope?" And he said, "I'm afraid not." Well, what were some of the other jokes? You see, the problem is I left my 3-ring binder in Peekskill. The problem is, Charles Dolan, you made me go to Peekskill, and there was no need of that, because I have a statutory right to my time slot, since I've had it, since 1995, for the rest of my life. The law says first come, first serve. It means first come, first serve. Can't you understand that, Charles Dolan? The law does not say first come, first serve. 13 weeks, every 13 weeks. Every time you do that, Charles Dolan, you are breaking the law. And you are violating people's rights. And that's why you get sued repetitively. Because you repetitively break the law. You, Charles F. Dolan. Cablevision. All right, so I had to go down there to get a local person to sign the application and contract, so-called. They're worthless. They mean nothing. They're totally unconscionable. They would never stand up in court. A real court, that is. And I left my 3-ring notebook down there, and that's my brains. And in that is a list of jokes to tell you this week. So I don't have to remember, try to remember what was on the list. Did you know that the devil sued St. Peter? And St. Peter said, I don't see how you're going to win. All of the good people are up here. The devil says, yeah, but all the judges are down here. Okay, what else was on that list to tell you for jokes? What's the plural of goose? Geese. This is the teacher. What's the plural class of mouse? Mice. Very good. What's the plural of baby? Twins. All right, I'm going to read you this other legal paper that went out yesterday. And in the United States District Court, this evil Clayton Schofield III wrote, they call it a report and recommendation. See, a magistrate cannot do a dispositive order in the federal courts. It can only be a United States District Judge, at least they know that much. And so what they do is they have the magistrate do all the judge's homework that he should be doing. And he reads the papers, and then he writes up a recommendation and a report. And of course, in my case, he wrote a report and recommendation that my case should be dismissed. All against the law, okay? And so Glendora doesn't even address, and you have 10 days to object to the district judge about this recommendation that your case be dismissed. Guess how I spell recommendation? W-R-E-C-K-O-M-M-E-N-D-A-T-I-O-N. This is a recommendation. And so Glendora addresses, notice that very, very clear, Glendora addresses Clarence Cooper, the United States District Judge, not the magistrate. Glendora addresses Clarence Cooper with her objections to Schofield's recommendation of December 18, 2002, and this is in the lawsuit Glendora versus Stephen P. Freon. He's another crooked United States District Judge in Oklahoma City. Glendora says, under penalty of perjury, Glendora tells the truth, the whole truth, and nothing but the truth, and always says, so help her God. Schofield and the defendants do not. Schofield does not get the recommendation to Glendora in time to answer in the 10-day limit. So why are the litigants limited to 10 days when judges take so much longer? And it is not fair. Service date on Glendora is December 18th pursuant to the docket. So Schofield says the service date is December 6th. Schofield sent a recommendation to wrong address. The post office delay in forwarding was more than 10 days. The allowed unfairly time to object. Glendora received it December 18th. Glendora telephoned the Atlantic Court and asked who her assigned United States District Judge was, and she was denied. Schofield is nescient. If an informer pauperis is denied, the case stops. An informer pauperis motion is to proceed without payment of fees. If the motion is denied, the case does not proceed. It's over. The United States District Judge has to grant the informer pauperis before he can proceed. Don't you understand that? Plain English? The United States District Judge has to grant the informer pauperis before he can proceed to a dismissal. Schofield does not know the Constitution nor the statutes. Schofield has no standing. Glendora did not consent to a magistrate pursuant to Title 28 U.S. Code Section 636, which says clearly, a magistrate cannot handle your case unless you consent to it. The clerk, when Glendora called on 12/20, was all wrong to say that her case did not have an assigned United States District Judge. Glendora has a constitutional right to an Article III judge, a United States District Judge. And I should have put in here that this was in violation of Rule 77, Federal Rules of Procedure, Civil Procedure, what a clerk has to do when you receive a case. You receive a case, you give it a docket number, and you give it a judge. Stop toying with the rights that Congress has given us. You judges, live by the law. Is that asking too much of a judge to live lawfully? Herein Glendora fully incorporates her objections to the court immediately following her receipt of Schofield's doing her out of her informer pauperis right. Title 18 U.S. Code Section 1915 is informer pauperis, that the court has to let poor people file. She incorporates the same as if fully stated herein. Now you remember that paper, I read it to you a couple of weeks ago. Schofield is biased in favor of the rich. He abnegates the poor. Schofield does not act in good faith. Judges do not act in good faith. Schofield does not know boy from girl. Glendora is a she. See the Bob Hope picture that I sent you of Glendora and Bob Hope. Schofield evidences further disability and misconduct in regard to Glendora's Rule 55, Federal Rules of Civil Procedure, motion for default judgment. These defendants did not appear. They did not defend themselves. And Glendora writes a motion for default judgment. Except Mediacom. Mediacom appeared, and they waived the cost of serving a summons. Give Mediacom credit. Who is Mediacom? That would be Commisso, Cool. That's his name. Cool. Arnold Cool. Stan Melton, and Kathy Goodman. What was their crime? They charged people for public access. The law clearly says that public access is at the cable operator's expense. And it's free to the public. That's what public access means. And then they charged to bump up a VHS to a 3/4 inch, when long ago they should have got rid of the 3/4 inch machines, 3/4 inch videotape machines, and installed VHS machines. The home format. Schofield is a hack, says Glendora. He does not do his job. He gives no grounds for denying Glendora's informer pauperis. What am I reading you? The reasons why the United States District Judge named Clarence Cooper should reject the recommendation of a teacher's helper called a magistrate, recommendation to dismiss Glendora's case, which stands up for all of our rights. Dozens of United States district judges have granted the same informa pauperis. There has to be a national policy in the United States district courts, just as there has to be a national policy as to Title 47 U.S. Code Section 521 et sec about cable TV and public access. Judges cannot rule two different ways on the same facts. Judges all over the United States have ruled that Glendora is a poor person and doesn't have to pay fees. So why do these judges come along and rule differently? You want to know why? Because they're cheating. Because the left hand doesn't know what the right hand's doing. Because they don't do their work, and because they don't act in good faith. Now that's an inconsistency. If I'm informa pauperis in 12 courts in the United States of America, I'm informa pauperis in the 13th. It's not a matter of opinion, being poor. It's a fact. Schofield's entire intent is to defeat justice. Yes. He obstructs justice. And that's against, listen to this carefully, folks. Title 18, that's the criminal code. Title 18 of the United States Code, and the section is, we get to remember this, 1503, obstructing justice. And that's what every judge you've been to has done, right? Remedies are who to sue, pick it, filing judicial misconduct and disability complaints under Title 28 U.S. Code Section 372, C, 1, and to expose on TV. Voila, here you are. You're their biggest enemy. You're the one they fear the most, you know. They get around everybody else, but you they can't get around. Now, Glendora's case cannot be dismissed. This is the case that Glendora won in the Second Circuit with Roger Minor. Glendora's case cannot be dismissed. However, in view of the well-settled rule, particularly applicable in pro se, civil rights matters, actions rather, that a complaint should not be dismissed unless it appears beyond doubt that the plaintiff can prove no set of facts in support of her claims which would entitle her to relief. They haven't given me the chance to prove that. So my case can't be dismissed. To it, left and right. Those idiots. Glendora's free speech and the public's First Amendment right to know. You have a First Amendment right to know. You know this, so that when you go into court, you know what's going to happen. And you can be on guard. And you can resist it. And you can fight for what is yours. Glendora's free speech and the public's First Amendment right to know are violated by this so-called court, quote unquote. Schofield papers are more dictum. Schofield's papers are mere dictum. They are rhetoric. They are conclusory. He does not prove his case. He denies pro se leniency. He denies pro se clemency. What's pro se? When you refuse to have a lawyer and you go to court yourself. You know, a lawyer comes after your rights. Your right is to stand up and represent yourself. Then the lawyers come along, and then they make you think that you don't have a right to represent yourself. You do. And you sue anybody who even intimates that you don't. Okay, I go through Schofield's illiterate recommendation to dismiss my case. I go through it line by line, paragraph by paragraph, interlinears and marginalia. And I point out everything that's wrong with it. From beginning to end. And I show them how the post office forwarded it, and that took up to 10 days. I don't care. I love the post office. The post office is a great service. For what used to be a few cents and now it's a few dollars, they do take things all over the United States for you, and I don't want to walk. I said the foregoing delineates a few of Glendora's objections to Schofield's recommendation. It should be stricken. It is worthless. It is anti-American, anti-constitutional, and contrary to the statutes. Dated December the 23rd, 2002. Yours in truth, Glendora, and the service list is to Cooper, the United States District Judge. I'm not even going to send it to the magistrate. Let him make his own copy. That's about all they're good for, is making copies. Center for Judicial Accountability Incorporated, and to you, the Glendora TV audience, and to Who to Sue, and to Commisso and Mediacom. And so it took all day yesterday, folks, to fight for your rights. But it's done. Did you hear about the couple? Yeah, they were posted by around 7 p.m. in the dark. And I should have taken the camera and videotaped the Christmas lights. These people really go out of their way. It's a great devotion for them. The Christmas lights. It's so nice. And you know, of course, the first day of winter is here. And why is that so great? Because of the daylight. The daylight's getting longer now. Every day gets about a minute or two longer. And boy, can you appreciate that. The dark days of November take a special effort to tolerate. But then we're thankful for them all. Dark or light, we're thankful for them all. A joke. You heard about the couple whose cars broke down so often they bought themselves the perfect second car, a tow truck. And you knew about the man who came home from work and he was dejected, and his wife says, "What's the matter, honey?" And he says, "They gave us aptitude tests at work today and I flunked." His wife says, "That's dreadful." He says, "Yeah, it's a good thing I own the company." Now, the lawyer said to the judge, "I want a new trial on the basis of new evidence." The judge says, "What's the new evidence?" The lawyer says, "I just found out my client has another $10,000. And there was a collision of two cars, and a third car pulled up, and a man gets out, and he said, "I saw the whole thing happen. I'm a lawyer. I'll take either side." And you knew about the doctor told Charlie, "You mustn't shovel snow. You'll have a heart attack." And so Charlie went home, and he says, "Son, will you shovel the snow for me?" And his son says, "Yes, Dad, I'll start immediately." And Charlie had a heart attack. Well, this is Christmas Eve. It's also the anniversary of our 48th wedding anniversary. The eve of our 48th wedding anniversary. We were married on Christmas Day by the Reverend John Elmo Wallace in the affluent community of Wellesley Hills, Massachusetts. The minister was more affluent than we were. And that was in the year 1954, Anno Domini. Now, we pray together, and we reach that great level that only a human being can reach, and we don't squander our time, do we? And we stay up there where good stands over evil, and good has the way, and good has the sway. This is Glendora, a chat with Glendora. The courage is flaming. This is snow number 8 on Christmas morning. It stopped snowing. It was snowing at 5 a.m. when I got up and came out. So this is hardly more than a ground cover. It's hardly a ground cover. Now come over here, folks. I want to show you how the wild animals eat their corn. They have corn and they have sunflower seeds and they have hazelnuts. Hazelnuts are $1.88 a pound. But that's all right. Give them this day their daily bread. And their bread they eat first. They eat their bread first. And then their nuts, I think, they eat second. And then their corn and... Oh, and then the sunflower seeds. Those go fast. And then the corn is last. That amazes me. I should think they'd eat the corn first. The chores got done yesterday, the videotaping got done, filing, paginating, hours and dollars got done for 15 extant lawsuits. And then Omnibus 14, Omnibus 10, the Cleveland failure, has been incorporated into Omnibus 14, and then Omnibus 13 you can't incorporate, but Omnibus 11 is the next big step to incorporate that one into Omnibus 14 because the Charleston, West Virginia court did not do their job for America. So you take it back again. It's like a return after Christmas Day. Christmas shopping. I think that bad dog who murdered that poor little deer lives down that place, down that way. The next big accomplishment of yesterday was 55 telephone calls, and today ended with taking care of the plants. 3 hours. Talking to the plants, taking off the dead leaves, cleaning them all up, repositioning them, giving them more room, watering them. And they all look very happy now. This looks better, don't you think? We took 15 plants out of here and put them into Office 3. So I think they all look happy. Last night we burned about 6 candles on Christmas Eve. I have seen this tree completely denuded of leaves, and all the leaves come back. So don't touch these because they might come back with leaves. So the chores got done, and 48 years ago, this morning, Franklin and Glendora were joined in connubial bliss. First legal paper of the day is a judicial misconduct and disability complaint against Patricia Gahn in the United States District Court, Cleveland. The second legal paper will go after the medical rip-off, the greedy, those who avariciously advance themselves through the sickness of others when they're the most vulnerable.
Sleep on this red towel and look out the window on the naughty cypress desk. Well, maybe we'll have to revise this. There's a cat who doesn't want to face it, or doesn't want to foot it. I have to show you a picture of this, folks. It's so beautiful before I disturb it. I have 4 gloves on. There. And now I got to shovel. What time is it? 3:07? All the legal papers are done, except one. That's the appellant's brief for Glendora versus Charles F. Dolan and Cablevision in the Rye City Court, where Glendora got her tapes back, but she never got any money. So that's all being appealed. Boy, this is at least 6 inches already. And I was an hour and a half cleaning the snow off of these cars, and as soon as you clean it off, it just covers up again. Got both of them running. So what can you do? I think you just have to wait it out. Gee, that was a funny thing. I saw a snowmobile going as fast as it could down this road. Wait for the plow to come. This is a path I shoveled out. I shoveled off the stoops, and look, they're all covered up again. Besides the snow, it freezes. It's all frozen underneath the snow. And my coat is frozen. It's what you call a wintry mix. Now we hope the plow will be back and plow out our parking spaces for the other people when they come home. These icicles grow so fast. Minutes ago, this one was only about 7 inches long. Well, the libraries have been very helpful since we are encapsulated with snow. White Plains Library looked up Standard & Poor's 1 and gave us 3 addresses and telephone numbers of corporations so we can continue asking CEOs to sponsor Glendora Cheerful Life on network television, daytime news, and prime time. And the Greenberg Library gave us 4. And Bill Houston, I'm not so sure about the information that he's using. Of course, Standard & Poor's will not be on a computer because Standard & Poor's sells that service, and they won't give it away. This is Katie eating peas. She loves peas, always has. And do you see over there behind Katie? You don't see any piles of work, do you? That 94 pieces of in-mail of December 18th. 94 pieces of in-mail have been processed and brought to a successful conclusion. And Vivian Folsom in Queens has sent her signature to Public Access in Queens and a copy of her electric bill, her Con Ed bill, to be the signer in Queens for a chat with Glendora. Good news on the Living Trust. We have read all of the chapters but 2. We're down to the next to the last chapter, and the rest of the book is forms. Isn't that wonderful? And Franklin wrote a letter to the Bank of New York telling him that he did not want to roll over his CD. He wants to put it in his checking account in preparation for the trust. If you take a CD out early, you get penalized. You lose money. And the words are good. Glendora can say 1 to 100 new words, 1 to 100. And then with 101 and 110 and upwards, a new policy, a new form of study is taking place. You use each of those words in a sentence. And let's see if we can remember some of those words. Acuity. Well, let's start with action. Actionable. Activate. Actuate. Aculeate. Acuminate. Acuity. Acumen. Acute. I think that's 9 out of the 10. Oh yes, act of God. An act of God to me is something good, but in law, the law definition is contradictory. It says an inevitable accident. No, that can't be. If it's an accident, it's not inevitable. If it's inevitable, it's not an accident. But then that's the way lawyers talk. Here is an inevitable injustice, apparently, in the United States District Courts. This is about Stephen P. Freott in Oklahoma City. He had a champion case before him, Glendora versus Munson, and Walker and a whole lot of other bad judges and bad people, agencies, who gobble up your money every week on their paychecks and then do nothing for you and turn the whole world toward their self-interest. And so Glendora caught him, and Glendora sued them. And this was an action. An action is a legal proceeding by which a person demands or enforces his or her rights in a court of justice. That's what an action is. And so Glendora did that. What was missing was a court of justice. Okay, so for his negligence and for his self-interest instead of public interest, Glendora filed a complaint against Stephen P. Friot. And she filed it in his 10th Circuit in Denver. And the judge there, Taka, as all of them are just as bad as the person you're complaining about. And so when they write back their second grade paragraph encloses a copy of an order issued by the Judicial Council on December 2nd, denying your petition for review and affirming Judge Taka's order dismissing your complaint. The Council's order is final, pursuant to 28 U.S. Code 372C, and is not subject to further review. Glendora versus Stephen P. Friot. And it's signed in purple. Isn't that cute? Now, Glendora says, "It is sad you are so deep in the abyss you cannot extricate yourselves. So I will pray for you and pray for America. Indeed, this is where I should have started. You have accomplished nothing for the USA. Yours in truth, Glendora, December 25th, Anno Domini." And up here it says that the circuit executive is hereby directed to sign, enter, and distribute this order to all parties as secretary to the Judicial Council. But she didn't sign it. Okay, David Tigg signed it. So the circuit executive didn't follow the order. She was supposed to sign. This is Opus 928, 1 hour, $3, print and postage. And the service list is IBID. The same as before. Isn't it sad? Here these people are in these lofty positions, and their work is abysmal. You think about Cablevision making you pay 10% more? Leave them. Go satellite. And what do you think about Cablevision changing the channel lineup? On the surface, prima facie, it looks good for public access because public access has come down from 70 to 18. That is a huge improvement. People get tired going up through all these channels. How many channels do they have? 98? This just happens to be peak scale. Yours looks something like this. You unfortunate Cablevision subscribers. This is a substitute notebook until I get down to peak scale and pick up my 3-ring binder, my brains. And I hope that's today. Looks good. I've been out at 5 o'clock. The moon is out there. Gemini's out there. Venus. So from here we hope to get on to Harrison and get a few signers for that crazy Dolan, who's going to bust our seams right down the middle with his superstructure of public access harassment. He doesn't have the people to enforce it.
because he fired so many people. So from here to Harrison, Harrison to White Plains to see Brad Sachs, Brad Sachs up to Route 9 to Peekskill and pick up the notebook, Peekskill up Route 9 to Walmart, and Walmart to the post office and to the bank. A man adopted an adorable Cocker Spaniel puppy from his friend, and he's coming out of his friend's house and he meets another friend. And he's holding this darling Cocker Spaniel puppy in his arms, and he says to his friend, "Joe, what do you think I got? What do you think of this Cocker Spaniel puppy I got from my wife? What do you think of this Cocker Spaniel puppy I got from my wife?" And Joe said, "That's not a bad trade." The little Hollywood extra got a speaking part in a movie finally, and he was thrilled. And the scene was, the detective would say, "Did you see the woman drink this cup of coffee?" And the little extra would say, "I did." He went home and he practiced all the different ways he could say, "I did, I did, I did, I did." When it came time to shoot the scene, the detective said, "Did you see this woman drink this cup of coffee?" And the little Hollywood extra said, "Did I?" A man came home from work dejected, and his wife says, "What's the matter, honey?" And he says, "They gave us aptitude tests at work today, and I flunked." And the wife says, "That's dreadful." He says, "Yeah, it's a good thing I own the company." A woman was in ecstasy over the car battery isn't charged yet. I started it before 6 a.m. And this is the little old half-hour battery, so we have to be frugal. We leave. Oh, I don't think I set the graphics on this. All right, this is Glendora, Chapel, Glendora, 8:38 a.m., December 27th, 2 days after Christmas, in the year 2002. Our camcorder is 3 years old, and I think we made the right decision to keep it. And we're in first gear until we get onto this highway. And it's as smooth as a Lincoln. 94 pieces of InMail are done, completed, brought to a successful conclusion. 94 pieces of InMail of December 18th, Wednesday. 9 days. The Taconic State Parkway. Putnam County. Why? To get television station. A local resident to sign a phony application and contract. Why is it phony? Because it's illegal. Glendora's been on the Harrison station since 1987. She's there for a lifetime. And Dolan took her off 3 or 4 times. And he has no right to do that. The law